And welcome to Justice Served TV. Michael Bryant here, and
Linda Kenny Bodden here. How are you, Michael? Nice to see you.
I'm doing well. I hear you are on assignment today.
Yeah, I was on assignment. I can tell. As you all know, I'm a poker player in my spare time, having been, shall we say, lured by a former FBI agent who teaches the WSOP Academy about poker. His name is Joe Navarro. He's an expert in tells. You can look him up, and he is transferred when he retired from the FBI, that ability to read people about tells into teaching about poker. So anyhow, my husband blames Joe, who we adore, we love more than anything in the world, for this little new habit that I have.
But I've heard today it wasn't working so well. It was that same
today was not one of those good days for me, but Monday night was. So
well, we have a bit of a surprise here. We knew we were going to talk to Doug Weinstein, Yak Gotti's attorney, Diamante Kendrick's attorney in the YSL case. We thought we were going to do it earlier in the day and not have him on live, because we know you guys like it best when he's on live, because then you can just emote and send him notes. But as it turns out, doggone it, here he is live and in color.
Hey, Michael and Linda.
Very snazzy.
Hey, Doug.
On there, bud.
Yeah, and you're working hard. When I took a day off, you were really working hard today.
Today was a day of hard work. Yeah, yesterday I had a day off. I actually had to go to a funeral of a friend of a friend of mine's father, and that was from noon until 10 o'clock last night. So
wow,
it's kind of a marathon, but that's okay. He lived a long life, 95 years old. So
oh my gosh,
that's pretty good.
That's pretty darn good. Yeah. Let's see where we haven't talked to you in a while, so we're trying to take advantage of your time and not bog you down with too much stuff here. Let's first talk about the new the furniture rearrangement in the courtroom.
Yeah.
I'm sure when the jury came back in, there was a lot of what the hell's going on here, and we actually saw it kind of in Wunny Lee's face when he took the stand. He was, in my opinion, he was representing the jury. He was pointing what's going on.
Yes.
Here. What was that like from your perspective?
The jurors did not seem all that surprised. I guess they figured something must be going on to be on break on so long, although, of course, we didn't tell them what was happening. But they didn't seem all that shocked. And then, of course, we worked out what the jury instruction was going to be, and the judge instructed them, and then we just carried on like nothing had happened. And yes, the two of us that are left, were moved to the front of the courtroom.
And those two are your client, Yak Gotti, and Shannon Stillwell.
And Shannon Stillwell, right. So Shannon Stillwell is sitting where I was sitting previously, and I'm over where Mr. Matthews and Mr. Huey were sitting.
Is that closer to the jury?
No, we're still.
You're still pretty far away.
No, the jury is still way, way over on top of the prosecutors.
Yeah, but they do have a direct line of sight to you now. They don't have to look over and back.
They do, and I have a good view of all the jurors, which I actually like. I like to have that, and I like for the witness to have to look at my client when they're testifying. So, in that sense, I kind of like being in the front. So I'm fine with being back up there. It's good. And the courtroom is very empty now. Just so you guys know, it is a giant, it's cavernous at this point, because we don't have all the lawyers and the various assistants and the defendants filling up stage left, I guess, part of the courtroom, left field, if you're looking from the judge's bench. And then we have fewer family members and fewer members of the media.
Well, we're interested. We're interested every day. We follow what's happening because, as we said, this trial is not over. I mean, this is pretty.
There was definitely some misreporting that, hey, it's over now. Jeffrey Williams took a deal. It's over. We were probably the first to point out that how ridiculous that was, and how it was poor reporting to even consider that.
Yeah, and I appreciate that. I had a lot of friends calling me up like, "Oh, what are you going to do with all your free time now?" And I'm like, "No, it's worse than before because." Because not only do I have all the work that I had before, but I don't have all these other attorneys helping out. And I've got to jump in when incidents relating to their clients are going to be brought up on the stand. Now I have to quickly get up to speed on that discovery and be prepared for any costs that I may need to do. Yeah. So it's more work.
And we certainly respected that. And when I bugged you earlier in the week, I totally understood when you were slammed. So we appreciate that. Let me squeeze
Thank you.
a question before you jump in here. There was a point where one juror said, I'm just so biased. I think the state stinks. I'm just telling you, Judge, I can't serve any longer. And the judge said, sit down. You're not going anywhere. What's your take on that?
Well, a couple of things. First of all, the juror had two issues. The first issue the juror raised with the judge is, I didn't expect to be sitting for this long. I miss my job. I enjoy what I do. I miss my job. I want to go back. And the judge assured that juror, we're going to finish by the end of the year. And we are. That wasn't a lie. We're going to finish by the end of the year. So that assuaged that issue with the juror. And then what the juror specifically said was, and I don't know if this was just inartfully worded, but the juror said, I'm biased against the decision. The juror did not say I'm biased against the prosecutors. Now, maybe that's what he meant, because that juror had said, after what I saw in the courtroom yesterday, I'm biased against the decision. And I'm presuming, I don't know what in particular they saw yesterday. Maybe it was the fact that $500,000 watch is missing. I'm not exactly sure. But if you notice, what did the judge say? The judge told the prosecutors, look, if that juror wasn't biased going into this trial, and if that juror has some bias now, that is a bias. It's not really a bias. It's a decision the juror made after witnessing the actions of the prosecutor, or the prosecution team. So the judge told the prosecutors, you made your bed, now you have to lie in it, which I think is totally proper for the judge to have done.
Yeah,
I don't know what your opinion is.
No,
Yeah, it's
no,
on you.
we talked. It's on you, and why you're mentioning that, because that also went along with the whole Richard Millay watch, right?
Right.
That supposedly is missing, and then people were online saying, "Well, no, one of the cops was wearing it," but
I don't think a cop was wearing it.
I don't think he was wearing it, right?
No.
But I mean, as everyone knows, I told Michael and I told our viewers that I learned about that watch when across the street from my office there's a Baccarat hotel, and somebody was rolled for that watch up in his room, and it was all over the New York Post, $1 million watch, $500,000 watch, with blah, 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 missing. And then the New York Post called the man's wife and asked what she thought of it. So,
Yeah. Obviously, I had never heard of it before because I wasn't even sure how to pronounce it. I think I said Richard Millay or Richard Mill because I wasn't sure which one it was.
Yeah.
But it's definitely missing. And you can see it actually in one of the exhibits I put up there. There's something that looks like a sunglass case. But if you look at that exhibit in detail, you can see the watch within that sunglass case. And there's other evidence that hasn't come in yet, but will, which clearly shows that watch. And then, of course, the prosecution team went and got the jewelry box, which God bless them for doing this. They got that jewelry box, brought it down to the witness. And I asked that witness to go through it. He said, I don't see it in there. And I said, well, I want you to really make sure. And that witness said, I've double checked, the watch isn't in there. So that watch took a walk at some point.
That's a pretty good day, no matter what, no matter who's in that courtroom left as a defendant.
That's a good day.
Yeah,
day.
Some of these collateral issues have such weight, Doug. They just put a bad spin on the prosecution as if they need another bad spin.
Yeah, well, I think it puts a bad spin. If you view law enforcement and the prosecution as a team, which essentially they are, then I think it does. It hurts the credibility of that team. If you are stealing $500,000 watches, are you planting evidence? I mean, there's obviously, you guys know what jurors may think once they see that. And maybe that juror that won it off and claimed he was biased against the decision, maybe that's what he was referring to.
Yeah. Okay. That's interesting. So you had also an interesting day today. Lyrics keep jumping up, and all these cases. There's a federal case now. The federal prosecutors want to use lyrics in the Little Dirk case, and we're blaming Fonnie Willis for all this. And today was kind of interesting. Michael was following it.
Well, as much as I enjoy blaming everything on Fonnie Willis, on Madam DA, I really can't do it on this one because prosecution teams around the country in both state and federal courts have been using lyrics against people of color for years. But I think what's unfortunate to me in this case, And I don't think if we would have litigated this in front of Judge Whitaker, we would have had the same decision. But she does not want to go back and revisit what Judge Glanville has done, which I understand. That could open the door to who knows how much litigation. So she doesn't want to revisit that. But if you look at what I think the courts that have done the proper analysis of the use of lyrics, it's always about nexus. Is there some nexus between the lyrics and the allegations? And in this case, there's just no nexus, but she has to abide by, or she's chosen to abide by Judge Glanville's decision. So there's no nexus there. And you saw the complications with lyrics. What did this mean? What did that mean? All of that confusion. And in this case, the lyrics really shouldn't be there, but we're stuck with them. And they're not, some of them aren't so great. And if Shannon Stillwell's lyrics come in, I don't want them used against my client. I'm far less concerned about my client's lyrics. They're very generic.
Yeah, you had an interesting attempted remedy for that. The
Cheers,
severance
by the way.
motion. Cheers, you deserve that.
Cheers.
Yeah, the severance motion. I thought that was a nice maneuver. But you got the instruction rather than the motion being granted, which is, you know, it's something. But it makes perfect sense. I mean, the last thing you want the jury to do is just lump you guys together when it's very specifically those lyrics were Shannon Stillwell lyrics.
Right. I felt that was a very Bruce Harvey move because if you've been following this case from the beginning, Bruce's client, Mr. Nichols, had very little involvement in most of this. His involvement was pretty much limited to accusations revolving around this Brinks murder, which didn't come up until after he pled out. So Bruce's involvement in the case has almost wholly been, as far as public involvement that people can see, wholly been standing up in court and requesting severance and a limiting instruction over and over and over again, and being denied actually on pretty much on both in front of Judge Glanville. But it was Max Sharp that reminded me I needed to ask for severance.
That's pretty terrific. So what happened today, Michael? I know you were.
Well, you know, I thought this was interesting, and it relates to the lyrics. You know, when you've lost the war, which you did under Glanville, the war being, did the lyric come in at all? Now you're stuck with the battles, all these little battles about what about this line? What about that line? And the judge, Judge Whitaker, has been pretty good at reading those lyrics so that everybody understands what you're talking about. And she was so comfortable, apparently, that she kind of dropped an N-bomb, the N-word, during one of her recitations of the lyrics. And it got a rise, I saw, out of ADA Hilton. I saw her kind of look. I don't know that I noticed any reaction from you specifically, but you're a little further away from the camera there. What was in that moment? Did you notice it? Did it make any impression?
I noticed it. I don't know whether I reacted or not. I have a terrible poker face, so the odds are I did react. I can't tell you. But I actually wish that issue would be dropped. And the reason I wish it would be dropped is as soon as we went on break, she realized what.
We just lost Doug's sound audio there for a second.
Hold on a sec.
And she apologized for it. So, you know, maybe I am not one that has the right to grant forgiveness or absolution since I'm not, you know, African American or Black. But I don't think she realized what she was doing. According to her, she immediately on her own apologized, and then right afterwards, Shannon Stillwell blurted out, "No problem, Your Honor." So, you know, that's over with. And there's not been a pattern of this with her. Everyone has an oopsie once in a while. That's all it was with her. And again, for everybody watching who's going to criticize me, I'm not just saying that because I'm in front of Judge Whitaker. I'm usually pretty straight with what I think.
No, I think she's proven. I think she's proven, given the Jeffrey Williams plea, that she's got some fairness in her that we were all doubted. I think she's absolutely proven that. She kind of had the prosecutor kind of dejected, and the whole thing with even the juror saying, you know, that's on you, you know, go elsewhere. No, I don't think anyone. And I thought the moment with Shannon Stillwell, you know, said It's no problem. That's it.
Yeah.
And we're not
I'm
we're not
sorry,
going
guys, because I'm going to have to drop off because I
Okay,
only have like a
let's find out
15-minute
real
window.
quick, like where we're going. The state is saying 2 more weeks. How long for the defense after that?
Well, that's a great question. And a lot of that, as you guys know, depends on the efficacy of the state's case over the next week or two. And I don't want to telegraph how many witnesses we're calling or what we're going to do. It's very dependent on the state and how successfully they present their upcoming witnesses. So I guess I tell a lot of people on TikTok and Twitter to stay tuned, and I'll tell you guys the same thing.
Well, we will.
Well, can I just promo you again? Your TikTok is fabulous, and your
Thank
Twitter
you.
is @Doug_Weinstein. And if you like him and keep giving him all those likes, he'll wear that fabulous shirt that's getting a lot of comments from our people.
Oh,
It's just
good.
wonderful. But there's his. Please follow him. I listen to his TikToks every day because it's not just about this case. They're about life. They're about how you treat people. He's
Thank you.
truly a gem.
Thank you. And thank you for having me on. And I
course.
don't like to leave until I thank everyone that's supporting us and following the case, because I mean that from my heart. Mr. Kendrick sees it. Please keep it up. And I'm so happy you guys have stuck with us, even though Jeffrey Williams, young thug, flat out. And I'm heartened by that, and not all that surprised given how wonderful our fans are. So thank you.
That's great. Thank you, Doug.
Have a
Okay,
great
bye.
weekend, bud. Take care.
You too. See you. Bye-bye.
All right. So always a pleasure and never enough time, you know?
Never enough time. He's truly he's just a terrific lawyer, and
He's a
but
good guy.
He's a good guy. His personhood it comes through, and how hard he's got to be working. And what people don't understand, and we talked about it with Doug, is the toll this takes on your life, on your family life, on what you're doing, on every thing. Just think about it. I mean, when Michael and I try to plan something, we plan something, and I say, well, no, I have to do this or I have to do that. He can't do that. He's got to be in this case for his client now 2 years. It'll start into the third year, and yet he maintains this affable personality, and one he's working hard for his client. It's just wonderful.
And it was when the other 4 dropped out, the burden shifted dramatically in terms of preparation, anticipation. I mean, all of that. Remember when we talked to him so many times prior to the plea deals, he would always say, yeah, I got Brian Steele. I got Max Shart, who he still has. But those guys were doing really a lot of the heavy lifting, especially Brian Steele with Jeffrey Williams as his client. Well, now, Max Shart are arguably the target defendant with Shannon Stillwell, but they're pretty darn close. Darn close. And you can't take a breath. It's all consuming.
And then they did start talking about the homicide, right?
The Drinks homicide.
The Drinks homicide,
which is the one that theoretically Shannon Stillwell is most closely tied to.
Right.
A lot of circumstantial evidence, but that works.
If you believe that, right? But that's all those the videos and where Gotti could have been and what car he would have been in if he were in the car, if that really were his. And this is where the prosecution now is trying to link by this association, even if Gotti, Doug's client, as you know, didn't have anything to do with it. This whole conspiracy, RICO conspiracy theory, and it's got to be very difficult. Yeah. Thank you, Missy, for the video. I didn't know Doug was wearing the shirt, but I had to kind of dress up for it Friday night.
Oh well. There's no what's that name of that scarf you had on? What's the name of that again?
Which one?
Beyonce or
yeah.
What was that?
It was a sweater.
Oh,
it was
sweater.
Balenciaga. Called it a billboard. Well, I guess I was wearing their billboard, but I was freezing. So what can I say?
So I wanted to talk to him about the instructions because I'm sure there will be some that are sticklers. There always are. For folks who may not be familiar, the standard instructions come in like a binder, and probably 9 out of 10 of them are not disputed in any way. They either are representations about the burden or about witness credibility, or, any of that.
Thank you. I'm sorry. Thank you.
Spunk.
I do have spunk. I mean, I go 23 hours a day. I have to keep up with Michael.
You're exhausting. So we didn't get to that, but next week, maybe if we get a chance to catch up with them again, we will. The deal is they're off Monday because it's Veterans Day. Thank you for your service. And then they'll start with the jury is officially back on Tuesday morning, but I think they're going to spend a little time, last minute questions on the instructions before the jury gets back in there. And I've heard the witnesses are going to be, because they talked a little bit about it today, some custodians of record relating to, it tastes so much better in this mug, relating to, thank you, Floyd. Wait, he's going to.
Oh, this is it. I'm sorry if this is off topic, but
It's not
I've been
really
wanting
off topic.
to ask. It's not off topic if Granville can be punished for his conduct in the YSL case. Really interesting you say that, because I was on a thing that he should just be disrobed and he should it should come off for his conduct. And I've said that about a number of judges.
I think he should
courts.
resign.
Well, yeah, where they, you know, they really should come off the bench and sit with the prosecution team, or as I would sometimes say, put their robes in a different color on if they're in a discrimination case. But when Ashley Merchant was on, she said it kind of had a lot of respect for him, believe it or not. She said that he is a military veteran Marine. He's got that gruff sounding, but he works hard, blah, blah, blah. But I really thought that his conduct, meeting with the witness out of the presence of Brian Steele and then jailing Brian Steele, was just quite frankly outrageous. And he should
I don't understand it. He was the chief, right? I mean, so he's like the head guy of those judges at that level. How do you get to that level? How do you have the reputation he apparently had, according to Ashley Merchant and others we've talked to that practiced in front of him, and then seem to go off the rails with this case?
Right, just off the rails. And you see, whatever Paige Whitaker has done, you know that she's going to the Supreme Court of Georgia, because she has handled this case now. She's taken a mess. Initially, we were criticizing her that she wasn't getting things done, but she seems to get things done, and she seems to have the respect of both the defendants and the lawyers now in that courtroom. And I think the jury probably.
I think so. You know, I have to believe that for whatever reason the defendants were whittled down from their perspective. She had a lot to do with it. I think that's going to be a perception, right?
But Floyd, I'd be the one that probably be jailed for contempt of a judge by telling them to get off the bench because you're just wearing the colors of whatever the prosecution team is.
But to answer his question directly, yeah, he can be. He can be censured. He can be, I mean, ultimately disbarred would be the ultimate punishment. That may or may not happen. But yeah, there's a number of different things that he could suffer as a result.
Right.
I mean, the most immediate was recusal. That's pretty bad to be a judge recused from any case. It doesn't get better from there.
Yeah. So we're kind of with you in answering that, and I hope that the reason why you asked that, in my opinion, is that you would like some kind of censure or some kind of punishment. Maybe that's a hard word. No, it's not a hard word. Punishment because of his conduct in this case.
Yeah. So we'll see next week into the instructions. If they say 2 weeks for the state, that means it's got to be 3, right? And we've got all of these holidays coming up. So next week is going to be short. The week after that's the last full week before Thanksgiving. Then you're into December. It's going to be, I think it's going to be tight to get it done by the end of the year with all of the breaks for the various holidays. But I do know, at least my opinion, once the jury gets this case, they have to wade through a lot. Remember, I think there were 62 counts. We
That's
know
the problem.
They've changed, and a lot have disappeared with certain defendants. The core is still there. There's probably a minimum. I'm going to have to do the math. A minimum of 20 or so for each defendant. So that alone takes some time just to wade through that. But I'll give them a couple of days. What is it they say?
I don't know. Well, it's supposed to be 1 day per week.
That's
right?
That'd be 52
gone.
Days.
That's gone with social media, and after 2 years, that's gone. This is cool. And I hate to say it, but this is kind of like more like the O.J. Simpson case. They've had this for so long.
Yeah,
a long time. And there are 2 types of jurors, just so you know, our viewers know. We'll have to, and Michael will answer the question about the wristwatch. But the 2 types of jurors.
It's not this one. I'm safe. It is not my $40 Timex.
Jurors that want to find for themselves, right? And jurors that go in and say, "Okay, well, what do you think? Let's take a vote. Let's see where we all are on the general theory of the case." And so those come back pretty quickly. Okay, we don't think they've done anything wrong. The danger of this case, of course, is that, well, maybe we should find them guilty of something, because they wouldn't be here. And that's the danger that the defense has in this case.
Yeah. And again, that's all of that, to me, that all stems from voir dire. I mean, those biases, if you can't ferret those out, they're going to hurt you in any case. Anybody that says, well, he was arrested for some reason, must have done something wrong, they can throw a wrench in the whole works because they aren't as concerned about evidence as just apprehension and the trial. So hopefully that doesn't happen, but that could lead to a hung jury. I mean, I think, to be honest, I think a hung jury is the best thing that could happen for the prosecution. That's the best thing that could happen.
That's the best thing. Yes, Floyd, thank you again for the answer. Your perspectives appreciated. Anytime, we really appreciate you being here at Justice Served TV with us. As he said, as you know, we're kind of young starting this, but we call it as we see it. I'm a former prosecutor, defense attorney, as you all know. Michael has just done everything fabulously. He's our camera on the ground. He goes into the courtroom, which we'll discuss in a little bit, and his perspective and his ability to grasp and relate things to you all is just it is remarkable and well deserved that he has an Emmy. Someday he'll show it. He'll show it. The Watch. I'm upset that there's been no investigation, or maybe there has been an investigation that started and they've been barred from discussing it, right?
I would think so, for sure. I mean, it speaks for itself when it's clearly missing. The jury's going to put their own spin on how and why, and none of the possibilities are good. It's either downright theft by somebody in the department or it's mismanagement of the evidence. Either one's not good for the prosecution.
Yeah, neither is good. But except the ultimate determination of whether something's good for the prosecution comes whether or not the head prosecutor, Madam DA, Fani Willis, is rewarded or punished, and she's rewarded because she was reelected. And so you may find that she may find that she goes upwards just like Judge Whitaker does in terms of her career. Yeah.
Her effort is so removed. We know she started the ball rolling, but unlike Glanville, it wasn't like she was in the courtroom every day making decisions and rulings. So I think she's somewhat insulated from that kind of punishment. The best punishment would have been voting her out of office. That did not happen.
Right. Oh, Coco, thank you very much. You know how my feelings in the death trial. As a matter of fact, one day we'll have Ben Chu on. He's become a dear friend of mine, and he and I are now going to be teaching together at Harvard the first week in trial advocacy workshop. It's a 3-week program, and we'll be at the first week this year, which is January 6th. So I don't know if I'm going to be doing this from there because we go until like 11 o'clock at night, or Michael will have a substitute there. But yes, thank you, Coco. Thanks for following us.
Yeah, I think I interviewed him at least once during the trial from Law and Crime. Just a good guy, another good guy.
Another good guy, right? Another good guy, another good guy. I do have to tell you that after the trial's over, he tried to get me tickets to Bethel Woods, which is where I'm near right now, which is where the original Woodstock was, to meet Johnny Depp. And unfortunately, that kind of failed miserable. I had tickets, but they didn't get you past the security, although we did get a tour of the back. Yeah. But that's because my husband got recognized. They said, Michael Bond from the New York State Police. So nothing to do with me or Ben.
Oh, well, that sounds like fun, though. Like a fun trip.
Yeah, he will. So we'll get him on. We'll get him on soon. He just changed firms, so he's probably just getting, feeling into the firm. We try not to bother people, by the way. Michael and I try not to bother people when we know that they're, adjusting to something new or trying a case.
If you've ever tried a case, you just know. I hate to be the family member of this person trying a case because you're not getting the attention maybe you'd like, nothing else is in your brain. Everything revolves around this piece of evidence, this witness. How am I going to handle this problem I know is coming? But that's part of the fun, in a weird, twisted way. So.
Well, but it's not so much fun is that you've been covering another case, not so much fun for both the defendant and the victim in New York City.
Yeah, we should talk a little bit about the Penny case. It's funny. I was thinking about the crossover yesterday when there was the mistrial motion in the Penny case. I was in the courtroom for that yesterday, and obviously in YSL, they've reinvented mistrial requests at 50 plus at this point. But I have to think that the one that just took us to the brink led
Right.
directly to those 4 plea deals that whittled the case down now against the 2 defendants
Right.
who could
Absolutely.
not make a deal and were not willing to take a deal, and they would not take a mistrial without prejudice. So that's why they're there. So anyway, in the Penny case, some fireworks today. Again, this is the Daniel Penny case. He is accused in the death of Jordan Neely, May 1st, 2023. Neely gets on the subway, making some noise, rips his jacket off and throws it on the ground. Interestingly, that seemed to be a triggering event. One of the witnesses today talked about that. It was just so violent, the way that he did it. Anyway, so at some point, Mr. Penny puts him in a chokehold and takes him to the ground. And after about 5-6 minutes, he's unconscious. We're not sure when he really lost consciousness, but the hold was in place for 5+ minutes. And ultimately, Mr. Neely died. So you remember we talked yesterday, there was some outbursts in the courtroom, and the judge
Right.
had more than once, told us in the gallery, be cool, stay calm. And when Neely's dad, burst out with I couldn't quite hear what it was. It was just almost guttural, just like, and it was when the defense attorney during his mistrial motion was suggesting that Neely was kind of known as this unhinged nut job. That was the phrase, and that's what elicited the outburst by Mr. Neely's dad.
Well,
Today,
any parent would have an outburst with their child.
yeah, it's just, and I told you before, he was crying when one of the videos was playing. I mean, literally head down and shoulders, kind of moving like he's sobbing. So today there was there's a lot of rules, and I mentioned too, there's about a dozen law enforcement in the courtroom. One of our commenters, and I'll throw this in as an aside, mentioned that the cops are there in theory because of the threats that have been made to both sides. And this viewer said, well, it seems to me that if making the jurors anonymous doesn't tip them off that the defendant is, quote, dangerous, remember that's in a possible
Right.
appeal down the
That's
road.
it, right.
What does it do to have 10, 12 cops in the courtroom, to heighten this sense of danger? That's not helpful either for the defendant. Makes it sound like, well, what could happen? And it could spill over on their interpretation of this defendant. So anyway, they're very orderly. Jury leaves first, parties leave, and then the folks in the gallery. And the judge, of course, tells them, keep quiet. Well, some guy just starts talking loudly, animatedly, and he's told, you need to be quiet by the cops. He doesn't shut up. He gets louder, and then they're saying, take it out in the hallway. When he finally gets out in the hallway, he's still in one of the law enforcement officers' faces, and he says, F your rules. Now, I thought at that point, maybe they would usher him out, but they didn't. They were pretty calm, apparently, in the hallway, and let him kind of vocalize his concerns, and he just ultimately just wandered off on his own.
Oh, you mean they didn't put him in a chokehold in the hallway and
They
take
didn't
him
arrest him or
down?
nothing.
Oh, gee, you know why? Because in New York, a lot of times when you're in the subway, and you were there too, people, Neely was known, by the way, Neely was known for a lot of people ride the subway. As I told you, we have a source and said all the time he'd come in the subway. Sometimes he was loud, sometimes he wasn't loud, but he'd do his Michael Jackson and all. It wasn't like, and he's just indicative of a lot of people that are either in the subway, Times Square, and it's New York City. So we're kind of used to this kind of stuff. That's the difference from trying this case here, or charging this case in New York and charging it someplace else.
Yeah, and if people on the jury don't understand that, of course, we know that was a huge issue when they were putting this jury together. I was trying to find that clip of the guy I saw on the subway just the other day. I've buried it somewhere. I can't find it. But that was a huge issue, because the jury of Daniel Penny's peers would necessarily then include, people who kind of ride on the subway a lot, right? So.
Right.
That's some more of the witnesses that came in today. I don't think these were good state witnesses today, though. Let me just try and give you a sense of the folks that came on board.
Michael,
we were
before you do that, could we just tell people, because this is a question that's coming up, is the case being streamed? It's not. It's New York, and New York does not allow. Well, they do allow cameras in the courtroom, but no judge has given cameras in the courtroom. They can let them in sometimes for a verdict. They came in like when Trump was being tried, which is a case that we can talk about. We'll go by the wayside pretty soon. They let a photographer in, but the reason why Michael is there is because he is our camera. He is our streaming.
Yes, I'm streaming it through my short attention span issues that I've got. So anyway, there were 3 witnesses in particular today that I thought were really kind of harmful for the state. One of them we heard about from the defense in their opening statement. It was a woman with a 5-year-old son. She had a stroller, and she testified that she actually kind of used the stroller to barricade her and her child from Mr. Neely as he was getting louder and more boisterous, and as she described it, putting his face within 12 inches of some of the riders, and not touching them, but just like right literally in their faces. And she said, how did she describe her fear? I think it was rather colorful. Her name was Althea Giddings. She's on the subway every day. And he was saying things. She said, Neely said, I don't give a damn. I will kill a mother effer. I'm ready to die. And she said afterwards, she thanked Penny, the former Marine, for stepping in. So again, I don't think these witnesses were all that helpful for the state, but we do know they have to get out in front of this stuff. They don't.
Yeah.
The last thing they want is for the defense to call these people, so
Right.
they bring it out. And then on cross-examination, she was asked if Penny's lawyers had ever. Penny's lawyers asked her if she was told by the cops to, say certain things by Penny, like. Penny said, would you mind talking to the cops? And she said, of course. So the follow-up was, did he ever tell you exactly what to say or how to couch your experience? And the answer was never. So that wasn't it. I'm trying to find what she said because it was so colorful in terms of, that's what it was. She said, I was scared shitless. That's what she said. Pretty descriptive. Another guy, this was a guy on the stand. He was 29 at the time. He described Neely as extremely aggressive, and for him, I mentioned that jacket being thrown on the ground.
Right.
That as soon as the jacket hit the ground, I could tell it was going to be bad. Okay, so it had to be, and it's so weird because the other day I told you, the guy sitting there smoking dope right across from me on the subway, leaning.
Right.
He started taking his clothes off.
Right.
And whipping them around and
right,
like hitting my legs with them because I wasn't going anywhere. I was going to stay. As other people kind of moved away, I didn't feel threatened. I just thought it was weird and also very coincidental considering this case. So this guy
was that
said,
Center Street? Was that the subway going to Center Street? Going to the courthouse?
Yeah, that was the 4 train going downtown.
Which is interesting because a lot of these jurors, I would imagine, will be taking that subway to get to the courthouse, or getting near the courthouse where they're meeting. Right.
Because nobody wants to drive down there. But I do believe that my lady on the back row from the Upper East Side, my guess, she's taking a car service. I don't think she's in the subway.
Or an Uber.
Just a guess. Maybe.
I take a cab or an Uber down to the courthouse only because I have to be there on time. Okay. So it's.
Yeah, that's true. The subway is, it's always kind of hit and miss. Another quote from this guy, and he's been there in the Big Apple, as they call it in this article. About 7 years. He wanted to be as far away as possible. There was another level, he said, of desperation in Neely's voice. He was, quote, pretty terrified. So these are witnesses, again, that were there and had experiences that, in my opinion, helped the defense. What do you think?
Yeah, no, they sound like they are helpful to the defense. Remember, he's charged with reckless manslaughter for 15-year crime. They want 15-year sentence, recklessness, and he's then charged with criminally negligent homicide for the chokehold being on too long. I think that's probably how the prosecution is going to argue it and all. And the problem is if it were just attacking him, it'd be his perception. So now he's to the defense of others. So it has to be the other's perception of what they felt through him, right? So he becomes the others because he's defending them. And the lead case, and I'm going to repeat it again for our viewers who are too young to remember this, is Bernard Goetz, Goetz, who shot 3 people while he was a subway rider, and they were unarmed, and he was carrying a gun, and he was acquitted. Great defense attorney Barry Slotnick, who still is practicing law, but I don't think practices criminal law after that Bernard Goetz case. So that's the standard here, and so everyone knows it's serious, serious, serious. So the question is, do you have jurors? Do you think anyone could ever agree for a guilty verdict on anything on this? I don't know.
Yeah,
I think it's very hard.
They called Bernie Goetz the subway vigilante, which is how this is being couched, interestingly, by the prosecution, because vigilante is not a good thing. If he's the subway hero, that's a good thing. That's the defense position. But you put your finger right on the key here. It's not as much that he acted, it's that he maintained that chokehold as long as he did. Very George Floyd-esque.
Right. And that's why they teach cops not to use a chokehold, because in 10 seconds, you don't know, in 9 seconds, 8 seconds, when that oxygen supply is going to come off. But it's complicated more here because there's going to be a suggestion that there's a pulse that was found, but he could still be brain dead even with the pulse. And then was his death due to the chokehold, or was it due to something else, the additional drugs in the system, or something else, or the failure of the EMTs to get there? I think you said 21 minutes. Yeah,
yesterday the timeline set up by the 911 calls, and then the body cam footage of one of the officers where you can see the EMT coming down the stairs, the first responders, 21 minutes. The question then becomes in the minds of the jurors, okay, if he began the process with the chokehold, there's no dispute on that, how responsible is he for the ultimate result, even if there were these intervening failures?
Circumstances, right? Yeah.
So that's tough.
Very, very. I think it's a tough case for the prosecution, even though the people I know that have, as I said, it's this one person who should give us a camera interview, who said he was like 90 pounds. If he's soaking wet, 90 pounds, and everyone kind of knew him. And we see the problem is you see so many people with mental health problems on the subway, and in New York generally, and in big cities generally, we don't have services for people.
So what's the answer?
Another tragedy. I don't know. I don't know. I don't know what the answer is.
Maybe better use of funds, but that's a whole different discussion. On the way back from the courthouse, there was this guy just yelling and screaming. So nobody on the ground throwing things around. And you can see people. It's tense.
Yeah, but Jordan Neely, he entered that car alive. He just didn't drop dead from drugs, and that's the problem.
That's true.
Somebody points out that if there was cops, they'd say excited delirium, which has pretty much been debunked right now, and all. So yeah, you're absolutely right. So but it's still a difficult case. Now, the actual prosecutor in charge of this case, I think it's his team, was Joshua Steinglass, although you said he's not trying the case. That's the same person.
No, it is. Let me get my little notes here. I can never. It's Daphne Yoran. Daphne, Dafnayoran. Daphne Yoran. She's lead prosecutor, and there's another woman working with her. So
yeah. So, but you're right. They have to get in front of it, and we'll see.
And there's one more witness.
One more witness. Oh, I'm sorry.
No, that's okay. It's a free for all. This was a witness named Lori Citro, and again, the other witness talked about things just feeling different. Like, hey, we've seen this before, but something felt different, and that she used that similar phrase. She said she's been riding the subway for 30 years, but his rant, quote, felt different. So that's the message the defense has to get to this jury, that somehow not only did it feel different, not only did it trigger Daniel Penny's actions, but somehow justified him holding that chokehold as long as he did.
Right. And remember, he's being charged with recklessness or negligence. He's not being charged with the intention to kill. This is not a murder case here. This is not it's a homicide case, but not a murder case.
I always like to drive people to our community tab so they can, weigh in. The options I've given here are guilty of manslaughter, guilty of the negligence, guilty or of not guilty. Somebody called me out on that, said, well, I say hung jury, mistrial. I said I didn't include that. And I do have a gripe about YouTube's community tab page. When you create a poll,
Right.
It's like you've done it in concrete. You cannot go in and, in this case, fix my mistake by adding a fourth option. But as it stands right now, it's 45% say the negligence, the lesser of the two.
Yeah. Oh, can I just, yeah.
Yeah,
So that was
14%
45?
the top charge, and it's getting closer now. It's 40% for not guilty.
On the top, 40% are guilty, and then what was it?
45% of the lesser charge, and then 14% of the top charge.
Interesting. So, yeah. Can we double back? There is a question from somebody about Mr. Abate. Yeah, we're going to double back for you, okay? Because you've asked this a couple times, and you just see this goes by very fast and all. We're kind of a free for all. But can we double back? How can Mr. Abate continue to prosecute the case when he's been on the stand as a witness in his case? That's going back to the YSL.
Of course. So, what's your take on that, Mr.
Well,
Abate?
you can if Abate, I guess I should say Abate. You can if what you said on the stand is not subject to a real difference of opinion. Okay, usually you can't try a case as a lawyer, but if it's not subject to any a real difference of opinion, then you can.
And remember, it's hard to think of it in these terms sometimes, but the prosecutor is the attorney for the state. The state is the client. So he would not be allowed to do anything that is in the adverse interest of his client, which is the state. So that's going to control a lot of what happens.
Yeah. Okay, so that's the update. What's happening on Penny next week? You think it's going to be the medical, going into the medical, Michael?
I think I think they are kind of running out of the precipient witnesses. So it's likely they'll get into the medical, and they're only going to have 4 days next week, beginning on Tuesday. So that would be my best guess at this point.
And this case is going to come down, in my opinion, to, well, first of all, you think he has to testify, right?
I think we agree on that. It is, as we know, in any self-defense case, it's almost a given. Here, it's a little different because people could rely on all of those precipient witnesses and their statements about how afraid they were and how thankful they were that Penny stepped in. They could rely on that.
Right.
I don't know that it's a good move. I think they want to hear from him. I didn't mention yesterday when I was going through my notes, wherever I put them here, of the jurors, because I had my little diagram.
The one that we say how
I can't even decipher, but I do remember this. I remember seeing this guy and having this thought: is this guy could be Daniel Penny's little brother? He's got the same wiry kind of build, the same kind of curly, kinky, blondish hair, and very angular, because Daniel Penny is just, he looks like a Marine jaw. He's just very angular dude. So this guy, he's probably in his 20s, my best guess, maybe 30. But he really, it's like, if I saw them together, I'd think they're brothers. So
yeah, interesting.
He may have a vote based on that alone. I don't know.
Yeah, but if he testifies, the rule of thumb is that, if you testify in a case, that everything that you've done before as defense just like goes away. It comes down to your client on the stand. If there's a way not to have your client on the stand and still get a not guilty verdict, you try to do that, because my view is that putting your client on the stand many times is the quickest way to a prison cell. But the problem is that they're gonna take what he says, and if the prosecution can cross-examine him and he slips up in any way, and I use that term lovingly as a lawyer, the jury can hold, they can just like grab onto that, and then nothing else matters. Yeah.
So the wild cards here are twofold: the other witnesses giving their perspective, right, and the video. Remember, it's just like the Sarah Boone case down in Orlando. If we didn't have that video of what she did, it probably would have helped her because on the stand she could say whatever she wanted. And as you recall, she kind of created her own narrative for that 10-minute window between the first video and the second video to create the event that was necessary to justify her reaction and the spousal abuse defense that she used. Jury didn't buy it, obviously. Right. Jury, they didn't like her.
She's unlikable. She's totally unlikable.
And the video was brutal. So they had one of the best rebuttal cases ever. I'm drifting off into another story, but that rebuttal case by the state was so good in bringing up all of her past experiences with the police and videos she took of her mistreating him. So in this case, to bring it back to Penny, that video and those videos from the events that that afternoon are key. And the witness testimony, in theory, you know, he may not want to take the stand. I think it's, in this case, not as automatic as you might think for a self-defense case.
Interesting. So you'll be back there next week.
Yep.
Of course, we're all going to salute our veterans. Interesting that his trial is in the when he's a former Marine, and depending.
It is interesting, you know. Those are subliminal kinds of things that may make an impact.
Right.
Yeah, you're right.
And the jury will be allowed back in YSL. We'll continue to cover everything happening around the country. We may even have a ruling by next Tuesday in the Koberger case. A lot going on here.
There's something else, just my random thoughts here in the Karen Reed case. I think there was, remember that they were going to do some retesting of some of the GPS.
Right.
There's been a response by the defense to that saying it was way too techie for me, but basically they were saying that testing that was done originally should have been sufficient, and in fact would have exhausted any of the information that equipment had on it. So what's the deal? What's the point? The prosecution was saying there are new techniques now that would extract better, more accurate information. Defense is saying you're crazy, because this GZY chip and this whatever these chips are, they've already exhausted whatever information is on them. So it'd be a waste. So we'll see what the court ultimately rules on that. But again, we know they're also pushing it. In all likelihood, both sides have asked to push it till April. We'll see if that happens, but odds are that is definitely going to happen.
Okay, so we'll be covering all of these, and in the meantime, while you live your daily life, and it's Friday night, and you have loved ones to get to, me and my Duncan,
Have some more Duncan.
morning. That's it from this morning. I know you have a piece of advice, Michael Bryant.
Well, I am Michael Bryant, yes, and try to do the right thing.
And I'm Linda Kenny Bodden, and we ask you, if you like our channel, to subscribe, tell people you like it, share, and notify, and we will see you soon.
Have a great week.